When I first read Maine's Question 2, I felt that same chill I get every time the government wraps new restrictions in the warm language of safety. This proposal, set to appear on the November 4th, 2025 ballot, might look harmless at first glance, another so-called effort to protect communities. But as someone who studies both constitutional law and the real-world impact of these policies, I see something much darker beneath the surface. Now, before I dive into this, let's take a balanced look, because that's how we do it here. I'm going to explain exactly what this law says, what it changes, and why both gun owners and legal professionals should be paying close attention. Maine currently operates under what's known as a yellow flag law, which requires a qualified mental health professional to evaluate a person before the state can remove their firearms. It's far from perfect, but it at least includes a degree of due process and medical oversight. However, Question 2 would replace that with a full-blown red flag law, one that lowers the burden of proof to a simple preponderance of evidence and eliminates the mental health review entirely. In plain English, it lets authorities seize your firearms faster and with less evidence than ever before. And here's the twist. Even the Fraternal Order of Police, Maine's largest law enforcement union, has come out against it, but not because of constitutional concerns. Their statement called it a disaster waiting to happen, pointing out that it would make police encounters more dangerous. In other words, both citizens and officers lose. So today, I want to walk you through exactly why this proposal is raising alarms, from a legal, constitutional, and practical standpoint. We'll explore what rights it touches, what precedents it challenges, and why this seemingly small state-level vote could set a massive national precedent. Because when you combine legal ambiguity with political fear-mongering, you don't get safety, you get tyranny dressed as security. Let's start with the basics, because like any law, the devil hides in the fine print. Maine's Question 2 proposes to transform the existing yellow flag law into a full-blown red flag law. Now that might sound like a subtle tweak, but from a constitutional perspective, it's a complete paradigm shift. Under Maine's current yellow flag system, the state must first secure an evaluation from a qualified mental health professional before the state can remove their firearms. The legal threshold is high, clear and convincing evidence that a person poses a danger. This framework, while imperfect, at least includes a degree of due process and medical oversight before any property or rights are seized.
Question 2, however, strips away those safeguards. It lowers the burden of proof to what's called a preponderance of the evidence. Essentially, it's more likely than not. That's the same standard used in small civil claims, not in cases where constitutional rights hang in the balance. Even more concerning, it removes the mandatory mental health assessment, meaning law enforcement could confiscate firearms without any clinical verification of instability or threat. In practice, that means this new law would allow someone to lose their Second Amendment rights based solely on the testimony of another person, even before a single charge, arrest, or formal hearing. Police could act immediately without the layers of scrutiny that have historically protected citizens from government overreach. This isn't just a change in terminology, it's a change in philosophy. Red flag laws like this reframe public safety as preemptive punishment, assuming guilt first and demanding innocence later. And when the government starts lowering standards for one right, history tells us it rarely stops there. Now let's examine why this proposal isn't merely problematic, it's potentially unconstitutional on multiple fronts. Think of this section as our legal deep dive, the legal eagle part of the analysis. First, the Second Amendment. It clearly states that the right of the people to keep and bear arms shall not be infringed. The U.S. Supreme Court reaffirmed this principle in District of Columbia v. Heller, 2008, and again in New York State Rifle and Pistol Association v. Bruin, 2022. Both rulings emphasize that firearm regulations must align with the nation's historical tradition of gun ownership. There is no historical precedent for disarming someone based on predictions of what they might do. Next, the Fifth and 14th Amendments come into play. They guarantee that no person shall be deprived of life, liberty, or property without due process of law. Red flag laws like Question 2 invert that principle. They allow the seizure of property first, then a hearing later. That's not due process, that's retroactive justification. The use of ex parte orders, decisions made without notifying the gun owner, only deepens the violation. People could lose their rights before they even know a proceeding has begun. We also can't ignore the Fourth Amendment, which guards against unreasonable searches and seizures. When police enter a home to confiscate firearms without probable cause or a warrant tied to a criminal act, they tread dangerously close to violating that constitutional protection.
And finally, there's the Sixth Amendment issue. Because red flag cases are classified as civil matters, defendants aren't guaranteed court-appointed counsel. So if you're accused under this law, defending your rights means paying thousands out of pocket or facing the system alone. This combination of lowered evidentiary standards, lack of representation, and premature enforcement doesn't just undermine one constitutional principle, it undermines the entire foundation of American justice. In the name of safety, the state would be allowed to bypass the very safeguards that define a free society. That's why Question 2 isn't just another policy debate. It's a constitutional stress test. And right now, it's failing badly. Legal theory means little without real-world impact, and this is where the consequences of red flag laws become painfully clear. These laws don't just exist in textbooks or legislative debates. They play out in neighborhoods, living rooms, and sometimes morgues. Take Maryland, 2018. Police arrived at a man's home before sunrise with a red flag order in hand. The resident, startled by loud knocking at 5 a.m., answered the door armed, completely within his rights. Within minutes, he was shot and killed. No trial, no conviction, no proven threat. Just a man defending his home from what he thought was an intrusion. This is not a hypothetical. This is the inevitable outcome when due process is replaced by preemptive enforcement. Red flag orders often rely on subjective reports. Angry ex-partners, concerned neighbors, or even political opponents can trigger them. In many states, including Florida and California, these orders have skyrocketed since implementation. Florida alone issued over 8,000 confiscation orders in just a few years. Yet despite those numbers, there's little statistical evidence showing a measurable reduction in violent crime or suicides. Worse, the accused often face a one-sided courtroom. They may not even know their rights are under review until after the confiscation has occurred. Reclaiming those rights can take months and thousands in legal fees. Even if the order is overturned, the damage, financial, reputational, psychological, is already done. And this is the part nobody talks about. Red flag enforcement disproportionately affects law-abiding citizens, not career criminals. It targets people who have something to lose: property, reputation, freedom. It creates fear among responsible gun owners who now wonder, could a simple misunderstanding or false accusation cost me my constitutional rights? That's not justice. That's punishment without crime. If you think red flag laws spread purely out of public concern, think again. Behind every common-sense gun reform headline, there's a well-funded political engine driving the narrative, and it's been running for decades. Leading that charge are organizations like Everytown for Gun Safety, Giffords, and billionaire-backed networks tied to Michael Bloomberg and George Soros. These groups pour tens of millions into campaigns that rebrand confiscation as compassion. In 2024 alone, Bloomberg's network spent over $75 million promoting state-level red flag initiatives. The language is carefully crafted. Who could oppose community safety? But the reality is systematic disarmament, one state at a time. They've mastered the art of emotional manipulation. After every high-profile tragedy, the same talking points emerge. If only we had a red flag law. But when you follow the money, you realize these laws are less about saving lives and more about expanding control. It's a policy of fear. Even more troubling, some conservative states have fallen for the trap. Florida, often called the gunshine state, now leads the nation in red flag confiscations. Politicians once seen as defenders of the Second Amendment have caved under political pressure or federal incentives. And yes, that includes figures like Pam Bondi, who sat beside President Donald Trump during the infamous 2018 meeting and supported the idea to take the guns first, due process later. That single line revealed the mindset fueling this movement, that rights can be temporarily suspended for safety's sake, a slippery slope the founders explicitly warned against. To be clear, this isn't about one party or another. It's about power, who holds it and who gets to keep it. Because once the government normalizes taking rights before guilt, the framework can be applied anywhere, to speech, privacy, or protest. That's why this fight in Maine isn't local, it's national. Behind the slogans, this isn't safety reform. It's infrastructure for control, wrapped in emotional appeal and sold as virtue. And if the people of Maine approve Question 2, they'll be writing the playbook for every other state that follows. At this point, you might be asking yourself, what can we actually do about it? Because it's easy to get angry. It's harder to act. But the truth is, every state-level fight like Maine's Question 2 is a national stress test for liberty. When one state gives in, it sets a precedent that others will follow. First, awareness is everything. Too many voters walk into the booth thinking red flag laws are simply about keeping guns out of dangerous hands. They don't realize these laws remove the constitutional guardrails that protect all of us. So share this knowledge. Talk to your community, your friends, and your family. Let them know that a yes vote on Question 2 is a no vote on due process.
Second, demand accountability from your representatives, local and federal. Ask them whether they support ex parte confiscations or if they believe rights can be suspended without a hearing. If they dodge the question, you already know their answer. Democracy only works if we insist that those in power remember their oath to the Constitution of the United States. Third, remember that vigilance isn't paranoia, it's patriotism. That means more than voting. It means understanding your state's firearm laws, training responsibly, and supporting organizations that defend the Second Amendment in court. Groups like the Firearms Policy Coalition, FPC, Gun Owners of America, GOA, and Second Amendment Foundation, SAF, are already battling red flag policies nationwide. Finally, never underestimate the power of civil discourse. We win hearts and minds not through outrage, but through reason. When someone tells you that red flag laws save lives, respond with facts, court precedents, due process standards, and actual statistics. Show them how temporary rights restrictions tend to become permanent. In a republic built on liberty, no right should ever depend on feelings or fear. So yes, stay angry, but be strategic. Because protecting freedom isn't about shouting louder, it's about standing firmer. In the end, Maine's Question 2 isn't just a state referendum, it's a referendum on how much Americans value their founding principles. If passed, it would signal that fear and convenience can outweigh due process and constitutional integrity. And once that message spreads, it won't stop at Maine's borders. The Second Amendment, the Fourth, the Fifth, the Sixth, and the 14th, they all hang in the balance here. Because if the government can seize your property and suspend your rights without proving guilt, then the Constitution becomes a suggestion, not a safeguard. But it doesn't have to end that way. The power still lies where it always has, with the people. Each vote, each conversation, and each act of civic courage pushes back against the slow erosion of liberty. So yes, stay angry, but be strategic. Because protecting freedom isn't about shouting louder, it's about standing firmer.